Hey everyone, I want to talk this week about a recent case in Canada, usually referred to as the Twitter trial. For anyone who doesn't know the case, it's officially called R versus Elliott 2016. In November of 2012, Gregory Allen Elliott was charged with criminal harassment based solely on tweets exchanged between himself and a feminist activist named Stephanie Guthrie. Two other women from her political group subsequently made complaints to police as well, but one was dropped, and the only charges were from Guthrie and Riley going into the courtroom. This was essentially a case of a group of feminists thinking that a man should go to jail for publicly disagreeing with them. This was intended to be a groundbreaking case for the feminist cause. Ultimately, the judge found Elliott not guilty, but his life had already been disrupted beyond repair, having lost his job and being barred from the internet for 3 years until the verdict was finally issued. The internet was a key element to Elliott's employment as an artist. So I want to talk about why the judge found Gregory Allen Elliott not guilty. I'll put a link in the low bar so you can read the full 85-page decision for yourself. I found it to be a real page-turner, but I'm kind of weird that way. As a note, there will be an amendment to the decision after a hearing that took place on March 4th, in which the judge acknowledged that some of his comments about Mr. Elliott and his character in the decision were based on a parody account, which he'd mistaken as being things that Mr. Elliott had said himself. That was incorrect. From the article about that March 4th case, he also added that the tweet sent by the parody account could be considered impersonation with intent to cause mischief, which is a criminal offense. I find that very interesting, mostly because Toronto police showed no interest in rooting out the identity of the person who created the parody account of Mr. Elliott. I would guess it was somebody either in the group of Miss Guthrie's feminist political group, or it was somebody known to them. One would think that their investigation of the dispute taking place would have concerned itself just as much with the type of abuse that Mr. Elliott was being subjected to. As we will hear, many of the tweets sent to Steph Guthrie and her friends were responses to their character assassination of Mr. Elliott's name. The identity of the harasser who created that account is important to investigating who was being harassed, by whom. And as Justice Nazin stated, the creator of the account is likely guilty of a criminal offense. Yet Toronto police just didn't seem to care. Investigations ain't what they used to be. Now, onto the decision and the revelation of why the judge found Mr. Elliott not guilty. And feminists should listen to this before they continue making suggestions for how the internet should work. First of all, the judge found both Guthrie and Riley to be credible witnesses. Credible means he felt that they were being honest, and he rightly found them to be credible because the things they admitted to on the stand helped him come to the proper conclusion that Elliott was not guilty. Had they been less honest, less full of themselves, it would have been harder for him to see how unreasonable they were. Reasonable is an important word in the trial. Well, Guthrie and Riley might have actually felt afraid of their Twitter opponent, although I doubt that. Their fear had to be reasonable to find Mr. Elliott guilty of something criminal. This simply was not the case. The judge found that Guthrie and Riley's ideas about how much control they should have over someone else's use of the internet was completely out of line with reality. So here we go. Ms. Guthrie's fear came from the volume of his tweets, including those using only hashtags. She could not say that she saw all of them, but I accept that she saw a lot. But whether she reasonably feared for her safety requires me to inquire into her reasoning. Ms. Guthrie was operating on several premises that she made clear and I have discussed. Mr. Elliott's views were spurious and garbage and of no value. The contents of his tweets were irrelevant. If she didn't want to hear from him and blocked him, then he should not use her handle and risk her seeing what he had written. In these circumstances, these premises were not reasonable. If she was fearful solely because of the volume of tweets to her, mentioning her, or using a hashtag that she created or followed, then the reason that Mr. Elliott was tweeting and what he was saying is relevant to the reasonableness of the fear. I have discussed this in dealing with whether Mr. Elliot knew that Ms. Guthrie was harassed. The main premise that I find unreasonable is her perception that she could tweet about topics but not be exposed to his tweets, however spurious and invalid, about the same topic, even if the topic was him. All of Mr. Elliot's tweets at issue were responses to the attacks on him that I have listed, or a return to the original dinner and the Bendelin Spur dispute. I say all his tweets because Crown Counsel does not rely on the content of any one tweet to suggest harassment. His not letting go of a topic is stubborn and may be considered childish, but it does not provide a basis for a recipient of his tweets to fear danger, especially if the recipient is herself still making negative comments about the sender. Another premise of Ms. Guthrie's is that Mr. Elliot was not allowed to tweet using hashtags that she created, was closely associated with, or followed. But he was. She held a view of hashtags in Twitter, that is, she is entitled to, but according to this evidence, is not reasonable. The effect of P.C. Dahler's evidence on this point is that a hashtag is open to the world. Another important circumstance is what occurred after Ms. Guthrie unblocked Mr. Elliot and told him to stop contacting her. Leaving aside his hashtag tweets, he did so until November 5th. I have reviewed his 6 November tweets and the exchange that @PromRardyHeather commenced using hashtag AOTID. Ms. Guthrie testified that made her afraid. Her basis was that he seemed obsessed and fixated. Example, she was afraid by the very fact that he tweeted. It is reasonable that fear can arise just from the fact of someone continuing to contact someone after being asked to stop. That behavior could reasonably signify that the person who continued the contact was capable of anything since they ignored the request. Findings of reasonable fear are made on just that basis. I have done so myself in criminal harassment trials. But in this case, Ms. Guthrie's unreasonable premise that Mr. Elliot was irrational and had nothing valid to say meant that she never put his tweets into any context. The very fact of his tweeting any hashtag she followed or any tweet about her or with her handle harassed her. She would not even allow for the possibility that he had any reason, apart from the obsession with her, that she perceived, to tweet about her. Given that she had a leadership role in the campaign to denounce him, that is not reasonable. Do not restrict this consideration to physical safety, as Section 264 can include psychological safety. Though Crown Counsel argued that as a basis of Miss Guthrie's fear, I did not interpret her fear of danger to mean that. She particularly cited his knowing the neighborhood in which she lived, and there is no evidence that she feared for her psychological safety. But that fear must also be reasonable. At this point, I have already determined that Ms. Guthrie was harassed by the repeated communication. Had there been anything in the tweets of a violent or sexual nature, or that indicated the irrationality that Ms. Guthrie perceived, that could support a fear of danger on the basis that he would be capable of anything. But as I have discussed in relation to knowledge, I have reviewed all the tweets despite Crown Counsel and Ms. Guthrie not relying on any one tweet, and found no such tweet. The element that the fear be reasonable in all of the circumstances has not been established beyond a reasonable doubt. The charge is dismissed. So that's that. Stephanie Guthrie may have felt harassed, that's entirely subjective, but her harassment and her fear would not have been reasonable. Neither was her understanding of how the internet works. That is kind of relevant because Stephanie Guthrie goes around campuses giving lectures on internet and cyberbullying, and I'll get to that at the end. So the next judgment is Heather Riley, a good friend of Stephanie Guthrie's, who jumped in on the fun of harassing poor Mr. Elliot. Even if I had found that the 2 minutes of concern at the Cadillac Lounge amounted to fear for her safety, I would not find it to be reasonable in all of the circumstances. Ms. Riley wrote to Twitter that Mr. Elliot stalked her and eavesdropped on Twitter. She also tweeted to him on September 11th, right after the Cadillac Lounge incident, making this request again, publicly stop reading my feed and alluding to it with your tweets. Her fear that he might have been at the Cadillac Lounge and that he could escalate to offline and real-life harassment, although she had no idea what he would do, is based on her view that there is privacy in Twitter and that one account holder can dictate what another account holder tweets. But on the whole of this evidence, relating to both her and Ms. Guthrie, Twitter is not private, by definition and in its essence. On this evidentiary record, asking a person to stop reading one's feed from a freely chosen open account is not reasonable. Nor is it reasonable to ask someone to stop alluding to one's tweets. To subscribe to Twitter and keep your account open is to waive your right to privacy in your tweets. Arranging a meeting or a social event using tweets other than direct messages is like inviting strangers into your home or into your phone line while you talk to your friends. Blocking only goes so far, as long as you choose to remain open. I am not satisfied beyond a reasonable doubt that Mr. Elliott's repeated communications caused Ms. Riley to fear for her safety. But had I been so satisfied in relation to the Cadillac Lounge incident, I would not be satisfied beyond a reasonable doubt that such fear, based as it was on an expectation that non-direct tweets are private, was reasonable in all of the circumstances. The charge relating to Ms. Riley is also dismissed. Now, I didn't give much commentary on those judgments as I was reading them because I really don't think it was required. The judge pretty much said it all. So what I want to do right now is have a look at one of the seminars that Stephanie Guthrie gave at Fanshawe College. This was a seminar given fairly recently, just in February 2015. I'll put a link to it below. And she, as a feminist, has decided that cyberbullying should be called internet violence. She gives a fairly detailed description of how this violence takes place, the tactics that are used, and I'm pretty sure she won't be happy that I have put together footage of her admitting that these are the very tactics she employs, and my, does she think she's clever.
I think that the conversation about quote-unquote cyberbullying could benefit from its own terminology that more specifically captures what is actually happening and the harm that's caused. So I would propose the general term online violence. But the bottom line is that I would define online violence as the use of interconnectivity, instantaneity, and insulation of the internet and social media to facilitate campaigns of harassment, intimidation, humiliation, emotional distress, and terror against targeted individuals.
So I'm going to use clips from a TED Talk that Guthrie gave in 2013. And I'm also going to use some evidence from the trial to show the way she's employed some of these tactics against Mr. Elliott.
By confronting Bendelin in a public forum like Twitter, rather than, say, emailing him, I was demonstrating or performing the type of way that I thought would be good to challenge him. And my performance, like his game, was interactive. I invited audience members, if you will, to leap out of their seats and get on stage.
It's so fast and so easy to post an abusive comment.
I searched for Bendelin on Twitter and I found him in seconds.
So once upon a time, you know, when you had to go through these extra steps, you had all these extra opportunities to think about, like, do I really want to do this? Like, is this maybe really super harsh, what I'm about to do? Should I maybe not do this thing?
The tweet intentionally drew a parallel between his online and offline selves by asking if the game represented his actions IRL, or in real life, if you don't use the internet as much as I do. In another tweet, I suggested employers might just find his game objectionable and notified the Twitter account of his local newspaper.
We don't have those barriers anymore, so you can just go, boom, submit, and it's done. Some other features of online communication that will make online violence more common. Performance.
I was demonstrating or performing the type of way that I thought would be good to challenge him.
I think that there are a lot of harassers who engage in abusive behavior online, at least partly, to draw a reaction from an audience.
And my performance, like his game, was interactive. I invited audience members, if you will, to leap out of their seats and get on stage.
So online violence, if you're going to say it's harmless, let's talk about what it can actually look like. Online violence, it can be as mild as disparaging remarks about your appearance, your intelligence, your daily activity, or your social worth.
From Mr. Elliott's side, the whole exchange in relation to Ms. Guthrie was about what people talk about. Whether he would do the poster, whether he could drive her around when she was injured, or bring her alcohol, whether it was a good idea to campaign against Bendel and Spur and notify Mr. Spur's employer, whether he creeped her out at dinner, whether he was a misogynist, whether the charges of harassing women online were fair, whether he was trying to proposition an underage girl or an adult woman, or even, at the end, whether he was harassing her and her friends, or he was being harassed under the guise of being accused of harassment. He was accused of being sexist, misogynist, and tweeting inappropriately, but he denied all the accusations.
It can be retweeting and reposting to incite further harassment from the abuser's followers.
Ms. Guthrie, though in her perception not sexually harassed herself, retweeted 6 tweets that included Mr. Elliott's handle. Others she had learned had confronted him about his unwanted sexual tweets to them. She testified that she wanted him to know that his behavior was unacceptable, so she retweeted the tweets from other women.
It can be the creation of fake email and social media accounts in the person's name, in the target's name.
Not only was Mr. Elliott facing the reference to his sons, someone had posted a parody account of Mr. Elliott with a similar handle. Ms. Guthrie had been tweeting with her friends and laughing at Mr. Elliott. As she did not mention him, this exchange with her friends does not appear on the printout from the search that was done by police. But she agreed in her testimony that she tweeted all her followers, laughing at the parody account of someone she described as her least favorite creep on Twitter.
And it can be the use of your work contact info to put your economic position in danger, try and get you fired.
I suggested employers might just find his game objectionable and notified the Twitter account of his local newspaper.
So not only is Stephanie Guthrie a pretty much professional cyberbully, or as she would say, terrorist, she's quite proud of it, and she gets applause. Oh, what a world. Stephanie Guthrie. 2 other women from her political group subsequently made complaints to police as well, but one was dropped, and the only charges were from Guthrie and Riley going into the courtroom. This was essentially a case of a group of feminists thinking that a man should go to jail for publicly disagreeing with them. This was intended to be a groundbreaking case, which found Gregory Allen Elliott not guilty. I'll put a link in the low bar so you can read the full 85-page decision for yourself. I found it to be a real page-turner, but I'm kind of weird that way. As a note, there will be an amendment to the decision after a hearing that took place on March 4th, in which the judge acknowledged that some of his comments about Mr. Elliott and his character for the feminist cause. Ultimately, the judge found Elliott not guilty, but his life had already been disrupted beyond repair, having lost his job and being barred from the internet for 3 years until the verdict was finally issued. The internet was a key element to Elliott's employment as an artist. So I want to talk about why the judge... Hey everyone, I want to talk this week about a recent case in Canada, usually referred to as the Twitter trial. For anyone who doesn't know the case, it's officially called R versus Elliott 2016. In November of 2012, Gregory Allen Elliott was charged with criminal harassment based solely on tweets exchanged between himself and a feminist activist named Steph. In the decision were based on a parody account, which he'd mistaken as being things that Mr. Elliott had said himself. That was incorrect. From the article about that March 4th case, he also added that the tweet sent by the parody account could be considered impersonation with intent to cause mischief, which is a criminal offense. I find that very